How to pass your rental properties down to your family and avoid the probate process. So if you are holding your rental properties in your personal name, they will have to go through the probate process when you pass away. And during the probate process, they are effectively frozen. Your family will not be able to collect cash flow. They won't be able to sell the properties, generate any money from the equity. They won't be able to evict tenants that are not making payments. They won't be able to hire contractors to do renovations during turnover, maintenance, or CapEx repairs. And so they are effectively frozen. The executor of your estate can petition the courts to get some of the authority to do some of those operational things, but generally the rental properties are frozen during probate. The cash flow generated from those properties will go into the estate bank account, and your family will not be able to access those for any reason until the probate process is over. And because you are sending rental properties through the probate process, it becomes more complex, so the probate process takes even longer. Now, it's likely that you built your rental portfolio to take care of your family and give them financial stability in the event that you have passed away. But because you're holding them in your personal name, you're putting your family more at risk because they cannot access those properties when they need it most, when they have lost you. And so some of the ways that you can avoid the probate process with a rental property is a joint tenancy rights of survivorship, a transfer on death deed, co-owning the property with your kids, or putting the properties or the LLC inside of a revocable trust. There's 5 different options here. And so if you are co-owning that property or those properties with your spouse and you're holding them as tenants in common, when you pass away, your half of the property will have to go through the probate process. So a tenants in common type ownership does not avoid the probate process. If you hold it as joint tenants with rights of survivorship, when one of you passes away, your half of the property will automatically avoid the probate process, and then it will go down to your surviving spouse, and then they will own 100% of that property. When you pass away, all that they have to do is file a survivorship affidavit and your death certificate at the county clerk's office, and they will transfer your half of the property over to your surviving spouse, avoiding probate. Now, co-owning it with your kids, you can set up joint tenants rights of survivorship and co-own it with your kids. The risk of doing so is that you're exposing yourself and the properties to the liabilities that your kids may have. Now, they may have a divorce, a lawsuit coming after them from a car accident, or creditors coming after them if they lose their job and they cannot find another one and they can't make payments on any of their stuff. You would have to sell those properties to generate the cash that your kids would need for the liability so they can capture their portion of the equity of their ownership. So you're putting your rental portfolio at risk for that. Now, transfer on death deed is good if you are trying to pass it down to your kids. So you would have full ownership in your personal name while you are alive, and then you list them as a designated beneficiary. And then when you pass away, that property can be distributed out to your kids. Again, all they have to do is file a survivorship affidavit and a death certificate at the county clerk's office, and they will get ownership of that property and avoid the probate process. Now, let's talk about, for the revocable trust, an LLC option or in your personal name option. So if you're holding them in your personal name, you can put the properties inside the revocable trust and be the trustee while you're alive, maintain full control over the rental properties inside of the trust. When you pass away, you can keep them inside of that trust or distribute them out to your family. Now, if you do hold your properties inside of an LLC and for the asset protection, you would put the LLC membership inside of a revocable trust. When you do this, you need to make sure that you're updating your operating agreement for that trust to be able to own the LLC membership. Now, when the LLC membership is inside of a revocable trust, it's the same thing. You can maintain full control over the LLC membership while you're alive as the trustee. And then when you pass away, you can go through all the different options here. So the options after you have passed away is that you can keep the properties or the LLC inside of your revocable trust, use those properties to be able to take care of your surviving spouse for the remainder of their life, and then you can distribute those properties out to your kids when your surviving spouse has passed away. Or if you do not want to distribute those properties out to your kid, you can keep them inside of the revocable trust, have the trustee manage those properties or the LLC on behalf of your kids. That way your kids can benefit from the cash flow, but they won't have to manage those properties and have ownership of them themselves. And you also can control whether or not they're going to sell that property when you distribute it out to them. So if you want help setting any of this up, click the link in the bio, the YouTube description, or in the comments below. Schedule a time to talk some more to our team.